Okay, I'll start a minute early. Good afternoon, everybody. Welcome to the annual Registrars meeting with the Land Law Bar. My name is Brian Asmundson, for those that don't know me. I'm Registrar of the Land Titles and have been in this position since August of 2022. To my right is Matthew Yap. He's the Director of Legal Registries. And prior to that, he was Registrar of Land Titles for at least 5 years. And in the back, Prosper Puwai. Did I say your last name right, Prosper?
Yeah.
Puwai. He's also with us. He's a paralegal at our office. Previously, we called the paralegals document examiners. And I'd like to start out by acknowledging that this meeting is taking place on Chief Dry Geese territory, the traditional home of the Yellowknives, Dene First Nation, and also the traditional territory of the Talitcho, along with other Indigenous nations who call this area home. We're going to give you an update since our last annual report, which was January 26th of this year, of last year, sorry. And I'll address some recent issues and miscellaneous topics. Secondly, I'll talk again. Are people online able to hear me?
Yep.
Good. Secondly, I'll talk about some possible tweaks and minor adjustments to the Land Titles Act, many of which are the same as the year before. We haven't yet put them into legislation, but I'll go over them a little bit quicker this year. And finally, I'll finish with a couple of interesting cases. We're scheduled for an hour and a half. My presentation should be under an hour, but I welcome you to ask questions during or after the presentation. This event is being recorded and it's available via Zoom or Teams, I understand. And you should be able to claim this for CPD hours. I checked with Rowan Brown. So whether you're watching here in person or online at CPD, you get your credits. Okay, annual report. Well, I'm gonna start a little differently. I'm gonna start with an interesting fact. Between 2001 and 21, that's a course of 20 years, there was a 365% increase in house prices on average in Canada. I believe that Vancouver and the Toronto markets distorted the percentage increases, and I don't think the increase in Yellowknife was that high. But interestingly enough, the cost of other things only rose 43% in the same period of time. And population increase in Canada, no doubt, is one factor, but okay, so I'll move on now to the annual report. We were largely fully staffed last year at Property Registry for land titles. However, we have a couple of our staff that transferred back to the corporate division or transferred to the corporate division. And that's two of our staff, land title staff, are now in the corporate division. That's Jessica and Pierre. They are in corporate now. Madison Penny is our current bilingual paralegal assistant. She's been in this position since January. She's a previous summer student at our office for 2 summers, so you'll recognize her if you come in. And Prosper is with us today. Lauren Banks remains with us as well. Lauren's, of course, the daughter of Elaine Keenan Banks. And Morgan Shaler remains our paralegal team lead and deputy registrar, and she's been with our office for over 10 years. And we have a surveyor. It's Maurice Power. He's been with our office since 1994. We're currently in a slow season, but we expect it to heat up again in spring. Okay, so each year we present you with our statistics for the year. And this past year, I've only done it to the end of the fiscal year here, which would be March 31st, 2024. And our numbers are down slightly from the year before. We had a big spike during the COVID, as did a number of other jurisdictions. It may be that higher interest rates had a little bit of a cooling off effect or possibly other factors. I'm told that Toronto and Vancouver volumes are down as well. Our personal property, I've just put those numbers on the far right. They are, we don't actually do too much with our personal property because it's managed by an organization called Unisys out of Nova Scotia. And they manage our personal property registry, and also they run the personal property registry for Nunavut, the Yukon, and all of the Atlantic provinces. So 7 jurisdictions in total. Our registrations there are quite similar to the year before. Okay, this is a backed by popular demand graph. And funny enough, I remember Alan Denroche saying last year he didn't want to increase his percentages anymore, but you've succeeded in doing so at your law firm. This is the proportion of accepted submissions. Now we have an other category, and under other, which is our biggest, or one of our biggest categories, we include First Canadian Title, FNF Canada, and Terranet. You might not have heard of some of those organizations, but a lot of them do discharges, mortgage discharges. So we get those usually in the mail. There is the odd mortgage, though, that does come through that way.
Mortgage comes through, the discharge is never.
Yeah, we often get a little bit of a, we have discharges have been coming through fairly slowly, so it seems like somebody pays off their mortgage and the discharges come a lot later, and that's something that I'll talk about a little bit later, how we might address that problem. Here's the 2024 private law firm submission rates, the percentage of submissions that are accepted as correct. And I put in brackets the numbers for that particular firm for the year before. I have not identified the firms in question, but and I've only done it for 7 firms, but if you want to know where your firm is in that list, you can email me or talk to me after this presentation and I'll let you know. But I'm pleased that the average is actually for the 7 firms was more than 77% this year. That's an increase of 6% from the 71% the year before. We've kept it anonymous, like I said, but happy to let you know. And I think, again, a fair comment to say here is that the firms that do the most real estate have the highest successful submission rates, because experience helps, I guess. Okay, next slide. Oh, this is our average turnaround time. Matthew has set our target as 2 business days or less, and I'm pleased to say that we actually achieved that last year. Our average for 2024 was 1.7 days. The year before that, 2023, it was 5.2 days, and it was 8.3 days for 2022. We were more fully staffed last year, which helped, in addition to our normal summer volume being down slightly. Again, I don't know if it's higher interest rates or maybe a little bit of a slower economy, but the numbers were down slightly. We continue to use the same NTLS system at our office. NTLS stands for Northwest Territories Title Land System. Our system is now maintained by the GNWT internally. It's ISSS that maintains our system. The developer of our NTLS system retired and was from Ontario. Yeah, we anticipate that we will continue to use the same NTLS system for the very near future. Okay, recent issues and miscellaneous topics. Now, in this next section, I've tried to come up with some issues that have come up over the last year or so, and which were not previously discussed. Some of what I might be discussing might be a little bit of a refresher for the experienced legal lawyers or real estate lawyers in the room, but I thought it worth bringing up for the audience here. First of all, this one is new this past year, the Apostle Convention. On January 11th, 2024, Canada joined the Hague Apostle Convention, which allows Canadian documents to be used outside of Canada without further legalization. Through authentication services in Canada, Global Affairs Canada and certain provincial authorities offer official document services to verify the legitimacy of Canadian documents. In particular, if you're notarizing documents for real estate in the USA is part of the Apostle Convention. And you need to send the documents, if you're doing this in Yellowknife, you need to send the documents into Global Affairs Canada to sign the authentication document, which basically confirms that you're a valid recognized notary in Canada. As well, if you're dealing with a client who is in the USA selling property in the Northwest Territories and the notary is in the US, they would need to follow the apostille process prior to sending the documents to Canada. Okay, there's a lot of information online on this, but I thought I would put up a little bit of it on the power slide. And there's the address in Canada that you need to send the documents to be authenticated. Basically, just to say you're a notarized, you're a valid notary in Canada. You also need to send back a self-addressed stamped envelope on or a prepaid carrier shipping label to send it back. I should tell you that I recently learned the hard way that the apostille process is not as simple as it sounds. My wife inherited half a cabin and some land in Montana with her brother. She signed in the Northwest Territories. And so the document needed to be authenticated or go through the apostille process. So we sent in the self-addressed stamped envelope, and then the postal strike happened. And so before they could ship it back, she was told that she's either has to wait for the mail strike to be over or to send it by UPS. And the cost for sending it to UPS through UPS went up to $200 for the documents, just normal like package of documents, not very thick. And the postage cost was only $3.50. So that's what you have to do in the Northwest Territories. My wife's brother was in Moose Jaw, Saskatchewan. He also had to get his notary authenticated. However, in Saskatchewan, this means just driving to Regina. And some other of the bigger provinces have locations. The smaller provinces do not, so you have to mail it in. There's no fee charged for this, but you do have to provide either a self-addressed stamped envelope or a UPS or some other courier package to send it back.
So Brian, how does Global Affairs Canada know you're duly appointed notary?
Good question. I believe we provided them with a list for the Northwest Territories.
So in this jurisdiction, all the notaries have to be registered with corporate registries, and we share the information with the federal government through the apostille process.
Yeah. Actually, in terms of registering with the Northwest Territories, I signed up when I started here in 2003 as a lawyer, and I found out that I had not provided a signature sample of my signature. So I did that a couple of years ago to make sure that I'm recognized. And of course, if you're selling property in the USA, you might have also withholding taxes, and you have to submit something to the IRS, and the gains or losses need to be reported to the IRS. There might be a withholding tax or withholding of 15%, which you might get back, you might not. And then, but there's no double taxation because of the Canada-US tax treaty. So whatever you pay in the US, you get credit for in Canada. Okay, And the certificate that you get back looks something like that. Global Affairs Canada has their own forms that they do up. And then once you get it back, you need to send it on to whoever the appropriate place or lawyer is. As I said, the information is largely online if you look. But Legal Registries does not authenticate here, nor does Service Canada. So you must send it into Global Affairs in Ottawa. The processing times in Ottawa, once they receive the documents, I just checked yesterday, they're about 10 days to process, and then another 5 to 10 business days to mail it back. Okay. Something that we've received a couple of in the past year are applications, a transmission application where both joint tenants are deceased. It's actually more common than you think, because what tends to happen is often in a husband-wife situation, one of them dies, and the other one's just like in no hurry, or still dealing with the death maybe, and they're not in a rush to do the application of surviving joint tenant, nor does it have to be done right away. But it's a very simple process. It doesn't cost much. It's only $30, and you only need a death certificate and an application of surviving joint tenant, which is fairly simple. And for the affidavit of surviving joint tenant, you just sort of need to explain in the affidavit that if the name on the title is different than the name on the death certificate, then you need to do up a statement in your affidavit that these individuals are one and the same. So if you've had both joint tenants die, there's a couple of ways you could do it, but this would be probably the best way, is just to file a transmission application for the last person that died. Now you might need to also probate the first person's items. I don't know. It depends on the particular situation. But we only need the letters probate for the last person that died, the last deceased joint tenant. And then we need the normal transmission application from the appointed executor or administrator. And we need additional statements in there as to the order of death. And if there's any name differences of the deceased between the letters probate, the title, or the death certificate, these need to be explained. And usually you need to put in a one and the same statement, as I call it, so that these individuals are one and the same. Maybe the middle name's W and it stands for Ray, and it's written out on the death certificate, but it's not on the title. That's fine. That's fine. But that just needs to be explained. Next slide. And again, as I said, you do need the death certificate for the person that first died, and that should be attached to the transmission application. And we continue in the Northwest Territories. If somebody died in the Northwest Territories, we will take a funeral director certificate. You don't always need the one from Vital Statistics, but if somebody died outside of the Northwest Territories, and a lot of Northwest Territory residents do, because that's where we back people out to. So you need in this case, the death certificate from Alberta, Vital Statistics, which you can get through Registry Connect. I believe the fee is something like $39. Okay. So we've had a couple of these in the last year. We've had a couple of situations where a person's become mentally incompetent, and so their family members are digging through to find the enduring power of attorney or the springing power of attorney. And unfortunately, because of our legislation in the Land Titles Act, we require the original power of attorney to be filed to register this. And this is for a transfer of land. We cannot at present accept a notarized copy of the power of attorney. We've had two cases, like I said, in the last year, where people done up these enduring powers of attorney, but they could only find one original copy of or one original power of attorney. I would advise lawyers, if you're doing powers of attorney, the enduring or springing ones, to make multiple copies for your client, because often I know the banks, they might take a notarized copy, but certainly they'll always take the original, so if you've got 3 or 4 copies of the original, that would be great. You can register an enduring power of attorney right away in our general registry at Land Titles. And it'll just sit there until the property gets dealt with by whoever the attorney is. Okay, so that's that one. Oh, just in terms of the court order that you would need, so if you need to keep that enduring power of attorney, there's only one copy, then you need to get a court order. And it's a simple court order, and it usually just contains it's a one-liner, as I say. And it would just simply state something like, the enduring power of attorney dated the blank day of blank, entered into by Jane Smith, is to be accepted by way of notarial certified copy for filing by the Northwest Territories Registrar of Land Titles. So this can be done by a desk application or an ex parte order. I think it would be wise for you to get our office to consent to the order before you submit it by desk application or ex parte. We're happy to do that in most situations, and you will of course need an affidavit sort of explaining the circumstances that you could only find one copy, that the Register of Land Titles needs the original, unless there's a court order that says that he can take a certified notarized copy. Thank you. Okay, next slide. I wanted to talk a little bit about problems with tenancy in common, and also I'm going to talk a little bit about problems with joint tenancy. Now, the Tenants in Common Act, I think it's like got to be one of the shortest acts in the Northwest Territories. It basically states that unless specified where an interest in land is granted, transferred, conveyed, assured, devised, or assigned to 2 or more persons, they take as tenants in common and not as joint tenants, unless an intention that the persons are to take as joint tenants is clear on the face of the letters patent, transfer, conveyance, assurance, will, or other assignment. Now, this is the opposite of the common law, which said that if real estate or personal property is granted to 2 or more persons without any words of severance, then the individuals take as joint tenants. And other jurisdictions also seem to have similar legislation. So next slide. What do you do if a client discovers they're on title as tenants in common and they want it to be joint tenants? Well, as long as this is what they wanted to do at the outset, but they were unaware that they were being put down on title as tenants in common. And so this was an error made at the outset, and incorrect information was given at the time title was created. We will accept what's called a statutory declaration, which you can file for $30 at our office. And the statutory, next slide, the statutory declaration needs to have a statement that the registered owners intended to hold titles as joint tenants, and a mistake occurred in the pursuant to document that created the title to incorrectly hold title as tenants in common. As I said, it's $30, but this can only be done if that's the way they wanted to hold title at the outset. So if they intended to hold as tenants in common and now they want to do a joint tenancy, then they have to do a transfer of land in that particular case. because there was no error made at the outset. Okay. So,
In what order unilaterally do a transfer?
in what order?
One, there's two on title.
Yeah.
Let's say they're joint tenants. I don't want my better half getting everything, and I just go and transfer half.
Oh, yeah, I'm gonna talk about joint tenants in a minute. Yeah, you had asked that question earlier. I do have a little bit
With
more
everything.
information to provide. But I've said sort of the same thing in this slide as I did previously. But we recently had a case where a couple, I understand, they bought land from the city of Yellowknife. They did not have a lawyer when they came in and registered the title without knowing that the transfer would result in them holding title as tenants in common. And they brought it into the document that was brought into the land titles office from the city did not say that they were to be joint tenants, which is what they wanted. So, next slide. I thought it would include a couple of paragraphs in, they're in the process, or maybe this has gone through now, but they're in the process of doing a statutory declaration so that they can become joint tenants. And they put these two paragraphs in their affidavit. Basically that the transfer of land was prepared by the city. We were not asked by the city if we wanted to hold title as joint tenants or tenants in common. We had no information about this. We did not have a lawyer until a month after we registered the transfer of land. If we had been told the information prior to registry, we would want to hold as joint tenants. So we are submitting this statutory declaration in order to fix the error of omission of, and the common phrase used is that you want to hold title as joint tenants and not as tenants in common. Okay, so as you put those two paragraphs in your statutory declaration, assuming they're accurate, we would likely accept it. Okay, another problem I wanted to bring up about tenancy in common is percentages of ownership. Sometimes we get the law firms sometimes specify what the proportionate interests are to be allocated to each tenant, like 50% each. And then we indicate it on title. But if the transfer just says we want to take title as joint tenants, that's all we put down, or as tenants in common. We just put that they own the title as tenants in common. That may not be a problem for them, especially if they're a couple or something like that, or they get along, but it could possibly be a problem. There is no presumption that they own 50% each, or any presumption about how much each owns. So we just don't know. If it's not on title, we don't know. Oh, I looked at, I'm just speaking for myself here. I looked at BC legislation and they have a little clause in one piece of their legislation that says, if the interests of tenants in common are not stated in the instrument, they are presumed to be equal. So that might be something we could consider in the future. I haven't ran it by Matthew yet or anybody, but I just thought it sounded kind of good. But I also think that if we introduce something like that, we would not want it to be retroactive, because whatever somebody agreed to in the past, we're not going to alter that. But from this point forward, you need to specify your proportionate interest, or we'll presume, or there's this presumption that it's 50-50. Okay. So if you have tenants in common and they wish to have their proportionate interest specified on title, but they never did, they can execute a statutory declaration designating their proportionate interest, signed by all the co-owners, but only if the co-owners declare that they've always held interest as designated. So if they want to specify it's 50-50 and, you know, and we can alter the title. Again, this would be a stat deck, so it's only $30. You can alter the title and we'll put on there, it's 50-50 or it's 25-75%, whatever it is, as long as that's been what it always was at the outset. Now, if you're in a situation where A and B hold title together as tenants in common and they hold an undivided 1/2 interest, and they wish to change to a 25%, 75% arrangement, then A could transfer an undivided 1/4 interest to B. So there would need to be a transfer in that particular case. And one of the reasons I brought this up is because we had a situation in the last year or two where a mother and daughter owned a condo as tenants in common, and there was no proportionate interest on the title, just said tenants in common. The daughter surprisingly died first. The mother did not live in the place at all. It was unclear what percentage was owned by each. And there was nothing in writing, I understand. But the family got along here, and the executor for the daughter and the mother came together, and they reached an agreement to sell the property. There would have been two ways to do it. What they could have done is after the transmission application, which put title into the executor for the daughter's name, and then the mother owned the other part of the other interest. They could have executed a statutory declaration designating their proportionate interests. Or they could just simply sell the property without both agreeing to the transfer without specifying their proportionate interest. In that particular case, they just sold their title without specifying the proportionate interest and divvied up the proceeds. I don't know how, but they were family and they got along. So, but what if you're not getting along? So it's wise if you can do these things before death. Okay, now we're into severing a joint tenancy here on our next topic. At common law, a joint tenancy can be severed by mutual agreement. Our Alan brought this question up recently, and our Land Titles Office or Land Titles Act is actually silent, really, on how you sever a joint tenancy. The Land Titles Office, however, will accept a statutory declaration of all joint tenants stating their intention to sever the joint tenancy. The other thing, Alan, that I didn't bring up that we would accept is that a joint tenancy can also be severed by the transfer of one joint tenant's interest to a third party, as long as all joint tenants execute the transfer document. For example, let's say A and B own they're the joint tenants. If A wishes to transfer his or her interest to C, then A and B must execute a transfer of land which transfers A's undivided interest to C. As a result of such a transfer, title would be issued in the name of B and C as tenants in common. But again, we would require both joint tenants' signatures on that transfer, even though only one is technically doing the transfer. But as soon as the transfer is effected, then they would be on title as joint tenants.
Then you'd have to specify the proportionate interest around the payments.
Yeah,
I still don't know what they thought.
that would be wise to do as well in there. Outside of doing this in land titles, though, there's other ways that you can sever a joint tenancy that are recognized in common law. And I'm sure you probably read through quite a few cases in law school and they're in the textbooks, but I'm going to mention a few of them. One is a separation agreement, which is considered a course of dealing between all joint tenants amounting to a mutual agreement to sever and to create a tenancy in common. So, normally, if the land's not sold right away, then the separation agreement might deal with it. B would be the execution of mutual wills. And I would assume that in the mutual wills, you've treated it as tenants in common. C would be the bankruptcy of a joint tenant. And there's a few others that are listed in the textbook that I don't intend to get into, but again, that's a severance by the common law, which we wouldn't necessarily know about at the land titles office. Now, I did want to bring up, I brought up problems with tenancies in common. Well, I've noticed some problems as well with people owning properties as joint tenants. Now, I've just pointed out section 136 of the Land Titles Act. Basically, as soon as one of the joint tenants dies, the other's entitled to just simply proceed with an application of surviving joint tenant. They automatically become the owner of the property by operation of the joint tenancy. So it's outside of the will, it's outside of the probate process. And that's always been the case. At land titles, we don't need to see the will, we don't want to see the will, the probate. But I want to point out a couple, what's happened that I've seen in a couple of recent cases recently. And that is, in 2022, I became aware of a situation where a fellow died while living in his house in Yellowknife. And he had actually been separated from his ex-common law, I'm told, for about 20 years. I don't know if they had a separation agreement, but she lived outside of Yellowknife, had not lived in the house for decades, but she was still on title as joint tenants, as a joint tenant with him. Now, whether that was intentional or not, I do not know. But the sister of the deceased, and this, there was no children here. The sister of the deceased was very surprised to learn that the house was owned in joint tenancy, especially since her brother had not been with the ex for at least 20 years. So she went and hired a lawyer prior to the application of surviving joint tenant being submitted to land titles, and she immediately filed a caveat. So if you'll flip to the next slide. I don't have the full caveat here, and of course, Jane Doe is not the name. But the caveat had one line in it that said, take notice that Jane Doe claims an interest in the following lands by virtue of a beneficial interest in the estate of Joe Doe, deceased, pursuant to Section 6 of the Intestate Succession Act of the Northwest Territories, in the land described as follows. And then it listed the land. It was filed in land titles office. So presumably this fellow died without a will. And on the next page, I just stuck in Section 6 of the Intestate Succession Act, which would presumably give the sister, or make the sister, if she's the only surviving sibling, and if their mother and father had predeceased them, which I believe to have been the case, it would make the surviving sister the sole beneficiary if the house was in his name. Interesting, this house was owned free and clear, by the way, that he just completed his mortgage payments, so. So now the caveat's on title, and any new buyer is going to want the caveat off title. I don't know how much subsequent litigation took place, but I do know that both the ex-common law spouse and the sister got lawyers. The house was sold by a consent order by Justice McPherson, and the order instructed us at Land Titles to issue a new certificate of title in the buyer's name, free and clear of all encumbrances, of course. And there was no mortgage. Otherwise, the mortgage would have stayed on, but there was no mortgage in this case. And this was done without prejudice to the sister being able to, without prejudice to the sister being able to assert a legal claim to the sale proceeds of the property. So although I don't know what happened between the two lawyers, I presume they reached an agreement that the funds were gonna sit in trust until litigation either went to court or it settled.
As a practical note, and if there's orders, presumably if there's easement agreements for power lines, gotta make sure the court order doesn't say free and clear encumbrances or who's been struck, correct?
Well, that's correct. The easement should go with an easement with respect to power lines.
Because I've seen foreclosure orders where they say free and clear, and it's wiping out.
Yes,
lines.
we've seen that too. Sometimes we've sent those back, by the way. If you do want to pre-vet a foreclosure order with our office, feel free to do so, but as Alan just said, a common error, and sometimes the judges sign these without, they make mistakes too. So next, you're looking at having to get rid of encumbrances, which obviously should stay on title. So. In this case, the encumbrance that got wiped out was the caveat that I just talked about, and then the lawyers dealt with it, I guess, by that agreement in the court order that the sister could still continue to litigate against the sale proceeds, which probably stayed in somebody's trust account, or at least a portion of it probably did. I bring this up because this is a joint tenancy situation where so the couple separated and it should have been cleaned up. I'm not gonna say right after you separate, but obviously 20 years was far too long to let this go on. Or there should have been an agreement that stated if this was the intention that the ex gets the property after he died, then that should have probably been in a separation agreement because there was some assets here. It wasn't a
Do you
situation.
know if they've been legally divorced?
I'm told it was a common law relationship, so, yeah. And just to let you know, I saw another file in our office where almost a identical caveat was filed. Similar situation, joint tenancy situation, had not been cleared up before death. Only one of the joint tenants was living in the house. So I don't know how that one will be resolved, but I suspect we'll run into some more of these where people decide or don't clean up their titles.
Of course, we don't know any of the details in the background when we see a document comes to the counter. So that common law spouse could have put the transmission application before any of this other stuff came in. We would have put the title right into her name. She could have then sold it and it was gone. It had been.
Well, yeah, that's the other part that's kind of scary here. Assuming the sister did have some legal grounds to stand on, the common law could easily have filed that application of surviving joint tenant as soon as she got the death certificate. We would have put it through. We do not, nor does any land titles registry across Canada, from what I read, we don't look beyond the death certificate where the parties hold title as joint tenants. We don't have to. The onus is on the homeowners to clean up their titles. Okay, common errors from submitters. Oh, it's not showing up. Oh, number 10. Oh, okay, schedules, or I'm just gonna read through this pretty quick here. Schedules or appendices are incorrectly referenced in the document or not referenced at all. Number 9, lack of proper signing authority or authority to sign is not clearly indicated. Document is not signed or dated. Number 8, incomplete document submissions. An example, power of attorney for the document executed under a power of attorney is missing. Letters of administration for a transmission application are missing. Number 7, incomplete or incorrect affidavit or jurat. No name, no date, no seal. Number 6, non-compliance with a statutory form. Number 5, 2 documents combined into one. Again, as I said last year, we do not allow a mortgage and a power of attorney document in our jurisdiction. Number 4, errors with names of the registered owner. Number 3, current encumbrances, including writs, are missing, incorrect, or incomplete. Again, you have to search the general writ registry at our office. If there's a potential judgment against somebody, it's not automatically on the back of the title in our jurisdiction, so. But if the name matches, then you have to prove to our satisfaction that it is not the client on the land titles, or the writ goes on the title when it's sold. And probably the lawyers deal with it through trust conditions to get it removed. Number 2 is error in legal description, and number 1 is the submitter did not review the document before submission. Okay, so that's kind of an old list. Okay, just a reminder for those of you not familiar. Well, I think when I started up here, actually 20 years ago, they used to have a board at Land Titles that would say how many days they were behind. What day they were working at. We don't have that anymore, so you need to check on the NTLS system. The bottom left-hand corner tells you the number of packages in queue. When we do first review and second review. After second review, the document's accepted. So it indicates in there how many days we are behind. So that's the best place to check. Possible legislation tweaks and case updates. I'm raising these again. Nothing again has been drafted yet or put into legislation. These are ideas that Matthew and I have discussed, and some of them were discussed with you last year. I'll go through the first one. Statutory abolishment of duplicate certificates of titles. I'm not going to go through this very much because when I discussed it last year, everybody's like, yeah, let's get rid of these archaic DCTs. No, the banks don't use them as security anymore. Years ago, they used to use them as security sometimes, and they'd have them in their vault, and okay, you got a loan for 50,000. We won't release the DCT until the 50,000 is paid in full. I don't know of anyone that does it anymore. But if they do, when we abolish them, which we would like to do, and I think you guys around the room would like to do, because they're a pain, because people lose their DCT. So all it ends up doing for most of the lawyers around the room is it creates more work, because you have to do an affidavit indicating that you search for the DCT, it's lost, it's not at any bank, simply can't find it. So if we abolish them, last year I said we were going to allow probably a grace period of 3 years. Now I reduced it down to 1 year. So if somebody does have security and are using the DCT as security, they would have 1 year from when we abolish the DCTs to register a caveat or whatever the security is against the title. Postponements, I'll go through that pretty quick too. We do not, this is just simply a section we don't have in our Land Titles Act. Most of the other jurisdictions across Canada have it. They are registered here, usually and often in the commercial transactions, where some of the big landlords, for example, there always seems to be a postponement in one of the big landlords' commercial mortgages, because usually they have more than one mortgage, and sometimes they get some new financing, and the new financer, or it's agreed, or it's part of the condition for the new financing, the old financer agrees, okay, CIBC, for example, can have priority with respect to the new $1 million in financing. So that needs to be registered on title, because it alters the priorities. And we don't have a form in our Land Titles Act. On the next slide, I'll show you the form in the Alberta Land Titles Act, we would introduce a form like that. I think there'd be less room for errors if we get our forms done, and we should, it's being done by caveat, and I don't think this is controversial or opposed by anybody, so. We would like, I think, to introduce this in legislation, but we haven't got anything drafted yet. And we're probably gonna copy, we also need to put a section in our Land Titles Act. We'll probably copy something very similar to this, or maybe outright copy it and steal it from Alberta.
Right.
Okay.
Nunavut allows. I've never actually looked at the legislation, I just filed it.
Okay,
Like you have to do, like you can't combine in one document, like if you have, say, 3 instruments that are being postponed, you have to have a separate document for each instrument, but you can file it directly, it doesn't go by caveat.
okay,
But I can't, but to be honest, I've never actually looked at their legislation to see what it says.
okay. Transfers of land. We mentioned this one last year. I will go over this one in a little bit more detail because maybe some of you have thought about it. But currently, section 76 sub 3 sub C of our Land Titles Act requires that each transfer describe each lease, mortgage, special encumbrance, or other encumbrance to which the land is subject. So that's usually at the bottom of the first page of the transfer document, the encumbrances included. Or a lot of the law firms, they just say, see attached copy of title. And they'll have the back of the title that has all the encumbrances that go with the transfer, that are allowed to be with the transfer. Now, in Alberta, we noticed they do not have a requirement to list encumbrances when completing a transfer. So we could bring our legislation in line with Alberta. Now, what happens, the current problem with our current way we do it currently is often a mortgage will be listed as an encumbrance, and then at the last minute, there'll be a discharge of that mortgage. And so we would not allow for the transfer because it says it's to that this mortgage is an encumbrance, and it's not anymore if it's been discharged. Or some other instrument gets discharged or maybe even put on. So we don't allow that. We bounce it. But we could remove the requirement and then you take it as is. So whatever the encumbrances are on title at the time of registration, that's what you get. The only thing we might have to alter here is with respect to writs. If there's a writ registered in the writ book, and if the name of one of the parties and appears connected to the land, we are thinking we would have to refuse such a submission unless there's a satisfactory explanation provided in advance that it's not connected to the land, or unless it's expressly agreed by both sides that it can be placed on the title. So if anybody's got any thoughts on this is going to result in you guys having to do more sub searches prior to submissions into the office. So you'll have to double check, I think, before you run over to the office or before your runner comes to the office to file things. You'll have to make sure that you're in agreement with what the encumbrances are on title. Is this something you guys want, or is there mixed feelings on that? Any comments?
Well, again, in Nunavut, you don't have the list of currencies, so. Works for me.
Yes.
I guess as long as registrations are the time frame that they are now, obviously get into 5, 6, 7 days, and get current searches, makes it a little more exciting.
Yeah, yeah. As long as we're not too far out of time, it's a little easier. Yeah. Okay. Next slide. This is just a form that Matthew's proposing we put into our forms. We don't have one in, but as you know, in every transaction, as long as it's not the first transaction involving the property. We need an affidavit regarding the value of the land. I'm not saying that the affidavits that you guys are providing haven't been adequate, but we don't have a specific form, so we're proposing to put this in. This is the one from Alberta. Okay, now I'm gonna get into some case law. And along the theme that we've been talking about, problems with joint tenancy and problems with tenancy in common, this is a case along those lines. This is an elderly father in Saskatchewan. He transferred his condominium in Yorkton, Saskatchewan to himself and to his son jointly, with the purported intention that the son only benefit after the father's death. So he was trying to avoid probate, among other things. This was a case where he gratuitously put his adult son's name on the title, ostensibly for estate planning purposes to avoid probate fees. After becoming estranged from his son, the father changed his mind about allowing his son to jointly hold title and to be sole beneficiary after his death. The son refused to transfer his interest back to the father. The father, now this is Saskatchewan law, the father was able to bring an application for an order vesting title to the unit back into the father's name with payment to the son if necessary. The application was granted, and the father was permitted to purchase his son's interest for $147,500, which was the appraised value of the 1/2 interest. So just some key excerpts here from the case. In exchange for the lessened probate fees, which was a mere modest 0.7% in Saskatchewan, transferring a principal residence may interfere with capital gains exemption. Transferring any property may make the property available to claims from the child's creditors or the spouse of the child. And it may hamstring a parent's control if a child disagrees with the parent's instructions or if the child becomes incapacitated. In this case, the father's use of joint ownership to effect an estate plan is unlike or different than providing a gift under a will. Under a will, the father could, of course, have changed the gift, but holding land in joint names is not the same. It's just a cautionary tale, and I know you guys in private practice probably get this all the time, and you have to explain to your clients why putting the title into joint names maybe isn't the right thing to do. I don't think our probate fees are that high up here. But last year, we had a mother and a son come into our office. And the mother, first of all, needed to get her deceased ex-husband off the title. She was a survivor. And she immediately wanted her son on the title as a joint tenant for succession purposes. Luckily, she made a couple mistakes and we were able to reject her application, but we strongly suggested that she speak with a lawyer about this prior to putting her son on title. I mean, she just drove in actually from one of the communities and she wanted this done right now. And I mean, I'm not saying that she shouldn't do it, but I really think she should think about it. Maybe next time I'll hand her Stubbings versus Stubbings and tell her to read through that before she makes the decision. Okay. The next case that I'm going to bring up has to do with this. And this is a picture of a sign in a neighborhood in the Bonavista neighborhood in Calgary, which has a man-made lake of 52 acres around it. And there's a homeowners association there. And I think they might even have some sort of fees for the homeowners association. They had all of their homeowners sign a restrictive covenant to prevent laneway houses. And I'm not sure what else the restrictive covenant did. I'm not saying this is a good thing or bad thing, but this was in response to the city of Calgary rezoning and wanting their community to be more dense, to get more houses built, to, you know, lower the cost of housing. But the community of Bonavista Vista fought this. And this was brought up at a land titles conference that I attended last year. And it appears to be a legal way to protect properties from future changes. In the case of Lake Bonavista, the restrictive covenant did allow for secondary suites actually, but it put parameters around what types of new developments and density increases that were allowed. And the article I read also suggested there's about 8 other Calgary communities that were seeking legal advice on how to counter the city council's decision on citywide blanket rezoning. And of course, Yellowknife's done something similar. Next slide. I'm going to get into this case. I should state at the outset that the case, they have a section in the Land Titles Act in Alberta that I'll point out in a minute that might make it a little bit easier for a court challenge. But this case involves the Glenora neighborhood in Edmonton, and the applicant sought to discharge a restrictive covenant from 2 lots in the Glenora neighborhood. And the restrictive covenant restricted building anything other than single-family dwellings on these lots. New zoning in Edmonton permitted, or it was introduced on January 1st, 2024, allowed for multi-unit residential development in the area, which conflicted with the restrictive covenant, or was thought to conflict with the restrictive covenant. And the section that Alberta has in their Land Titles Act basically says the first owner and every transferee and every other person deriving title from the first owner is deemed basically the restrictive covenant. They're bound by the restrictive covenant. It runs with the land. But any such condition or covenant may be modified or discharged by order of the court on proof to the satisfaction of the court that the modification will be beneficial to the persons principally interested in the enforcement of the condition or covenant, or that the condition or covenant conflicts with the provisions of a land use bylaw or statutory plan under Part 17 of the Municipal Government Act, and modification or discharge is in the public interest. So in Alberta, a restrictive covenant, next slide, can be removed if it conflicts with a land use bylaw or statutory plan under Part 17 of the Municipal Government Act. I did not find a similar section to our Land Titles Act. Matthew, or you're not aware of anything? Okay. But in this particular case, the court dismissed the application. It held that the applicant failed to prove an irreconcilable conflict between the bylaw and the restrictive covenant, and did not adequately demonstrate that discharging the covenant would be in the public interest. So 2 takeaways are: 1, to discharge a restrictive covenant under Section 48 sub 4 of the Land Titles Act in Alberta, it must be proven that there's this irreconcilable conflict with the land use bylaw, and that the discharging of the covenant is in the public interest. And I read the case, and it indicated that a restrictive covenant is not necessarily against the public interest. So they sort of started out with that proposition. Is it really against the public interest? The courts require strong evidence to discharge a covenant, especially when public interest is cited for the reason. So it must be substantiated with evidence, including details of planning and the consultation process, especially when there's significant opposition. There's more than one case in this area in Alberta, by the way, and I think across Canada. It's interesting. We also heard there's some they're gonna fast track some changes in Alberta. There's some bunch of restrictive covenants in malls that allow for only one grocery store, for example. and the grocery stores maybe long closed and left that mall. So they have, what in Alberta, they have these, they call them grocery store deserts. Where there's areas, you cannot put in a grocery store because the desirable locations. Are ones where the restrictive covenant has not been removed. And so you can't put it in grocery stores, so I don't know, maybe they might be working on some legislation to get rid of restrictive covenants in those situations. Okay, our Builders Lien Act, I did a presentation last month. It is not available online. It did not get recorded, I'm told. But it was passed on October 5th, 2023, Bill 65. We are still working on the regulations. I think we're very close now.
They're done.
They're done? They're done. So we're going to hopefully put something in the, will we put it in the notice to the bar? So that you can have a look at the regulations. Jeff made a suggestion at the presentation last month, and I think we put in his suggestion. And we made a couple of other minor changes. But for now, the Mechanics Lien Act still remains in effect. Okay, that's about an hour and 5 minutes, and that concludes the presentation, subject to questions from you guys. Any questions online? I think you can put them in the chat box. Is there
Nothing there.
nothing there? Okay. Well, thanks everybody for coming then.
Thank you for this, Brian.